We're so excited to have you with us today, Horace, and we're going to ask you to kick it off by just telling us a little bit about Article 5.
Well, thank you so much, Kathy, and I really, really love this organization, Constituting America. I think it is vital that this amazing, amazing charter called the United States Constitution be cherished, be supported, and be understood. Our founders really worked hard to create the first and longest lasting government charter on the planet. It is a remarkable, remarkable document. And so when I had the opportunity to be a part of this, I was just thrilled. And I'm so glad that the focus is really targeting our young people, because they're the ones that are going to be here. There are our posterity. They're going to be making these decisions in the future. And so we're focusing on Article 5 today, which I think is an instrumental component of our existing Constitution. I'm going to back us up a little bit in time. The year is 1215. It's the date when King John affixed his seal to what we now know as the Magna Carta. Britain, to this day, does not have an unwritten constitution, but the Magna Carta was a consequence of what occurred when King George, who appeared to have sort of an avaricious attitude with regard to the rights of the people who lived in what was then Great Britain and is now the United Kingdom. He got into feuds with the barons. He used his power to tax people regardless of whether or not Parliament had anything to say or do about it. He also made sure that if anyone disagreed with him, he reserved the right to be able to say he was going to have people executed. He was going to have people summarily arrested. He was going to have them held in a jail. Now, why do I mention all of this? It is precisely the experience that our founders, who their ancestors had come from Great Britain, who realized that there was a need, a missing ingredient for self-government. What the Magna Carta did was lay a groundwork for the idea that there are limits to what government can do. There are limits to how government can go about carrying out its responsibilities. Now, in 1215, there were a lot of problems that could have been addressed, but really only the biggest ones ended up occurring, making it clear that the king in the United Kingdom was not the final say with regard to government. It was the first written document that promoted this principle that government is not above the law. So when we had our Declaration of Independence, our founders understood that we see part of the problem that has occurred even with the British system, even with a royal leader in check with Parliament, there were still abuses that could occur, and that was the reason why the Declaration of Independence was written. And you'll look at it and you'll see all of the specific charges that are listed against King George at the time. So we started with what was called the Articles of Confederation. After we won our independence, for 8 years, we operated under this system. It was a system of a very, very weak central government. Our founders had initially feared what could happen if you had what was thought of as a strong government, and they thought that that's why they had the conflict with Britain, was because the British system was so centralized, was so powerful, that it didn't give the Englishmen who lived thousands of miles away overseas the kinds of rights and liberties that they wanted. So they created one Article of Confederation that had no power to tax. It actually required for any decision to be made unanimity. If one colony/state disagreed, that meant that whatever the initiative was, it was either tabled or it failed. It also gave every colony, regardless of the size, the same vote, regardless of the size, the largest state and the smallest state. And there was no executive branch that had the ability to administer it. So that led, after 8 years of indebtedness, pushing our free people at risk that they may be reconquered again, into a serious need. What could we do? How can we do it? And so in Philadelphia in 1787, our founders met, delegates were sent, and they adopted the Constitution. Now, I know everyone knows this, but what I want everyone to understand is this is why the Article 5 provision exists. What had happened with the old system was it was weak and it required unanimity, and there was no outlet for the public to be able to offer their input. The only input for the government at that time was the states. Now, our founders are interested in one real long-lasting principle, and one of the reasons why our Constitution has worked so well. Create a government strong enough to do the things that are necessary, but not strong enough to do the things that threaten the liberty of individuals. And they divided the government into various ways, and they limited the powers of the government in various ways. Again, the main purpose was to create a system in which the government was strong enough to do everything that it needed to do to maintain its integrity, its ability to protect its people, but not strong enough to overwhelm the liberty interests of its citizenry. Article 5 is a part of that. It's a key part of that. It is about the concept that the people ultimately, at the end of the day, actually are going to have input. It is the popular will. It is not simply democracy in a pure sense, but it is also not simply government unchecked. When the Articles of Confederation existed, if you had a complaint as a citizen or group of citizens, you had to petition your own state or colony, and then they sent their representatives to the government operating under the Articles of Confederation, and then they presented whatever their policy initiative might be on your behalf. And unless every single other government, state or colony agreed or abstained and didn't vote so that you were left with a unanimous vote, nothing could happen. And what you were left with was essentially a federal government that had no real component representing the interests of the public at large. Now, the founders did not ever want a pure democracy. I need to repeat that. They did not ever want a pure democracy, but they also didn't want a government that was unaccountable. The British system was a modification where the royal family, the king had, or queen, had a role regardless of who they were, when they were born, or their circumstances in their life. Whereas on the other hand, the Parliament, a part of it, was subject to direct election, the House of Commons, and then they had the House of Lords, where people were appointed. Our system was trying to improve on that. And so we set up the ability to make amendments to our Constitution. We wanted to make it possible for people, for communities, even for states, to be able to recognize serious problems and see those serious problems and attempt to modify our Constitution to accommodate to those. We have successfully done that some 27 times. Remember now, with the British system, it literally came to a head where the king himself, King John, could have lost his head as the only way to make change to the legal system. We didn't want revolution. We didn't want the threat of revolution to be the basis for making modifications. Now, in the case of the Magna Carta, these were some essential ingredients that many people today would say, well, of course the king can't lock people up at random. Well, of course you should be allowed a jury trial. Well, of course there should be a vote on what the tax rate was. But our system says there are answers to questions that have yet to be asked, and we want to make sure that those get answered, that there is a possibility that those questions get answered. The primary way of amending our Constitution is for Congress to take the initiative, enter a resolution, and if 2/3 of them agree, that will be considered a proposed amendment to the Constitution, and then it is sent to the rest of the country in one of two ways. Either we will have the states themselves agree, 3/4 of them agree to ratify it by a formal vote with 3/4 of those representatives, or those states may also hold many conventions that are called ratification conventions. Nothing else. You select delegates that the state has chosen, and the state may, in fact, send those representatives to its own ratifying convention, and they may use that as the basis for adopting the constitutional amendment. That's the primary way of having constitutional amendments. There's a secondary way of having them, and that is that if Congress has tried, or Congress is simply uninterested in trying, then the states themselves may generate a process for a constitutional amendment. Now, the state process that is initiated is different from the congressional process. The congressional process, you draft a specific bill, and that specific bill has to be passed in both houses, the Senate and the House, with a 2/3 majority. Then it's sent to the state. The state-initiated process is different. The states do not simply get to draft a language of a proposed amendment. They instead ask that an amendment convention be held. Let me repeat that. They can say, we would like a balanced budget amendment added to the United States Constitution. But what they can do, that may be their desire, but what they can do under the power that they have is to ask that a constitutional convention be initiated. And it is this power that has concerned some people who are critics of this portion of the ability of Article 5 to operate to allow for modifications. Since Article 5 doesn't limit states into saying the specific change that they want to make, if in fact 3/4 of the legislatures call out and ask to have a constitutional convention, then that convention must occur, and at that convention, presumably, the issue that motivated them to join up and agree, the other that make up the 3/4, are then going to be subject to ratification. Now, there's a caveat. The founders said that there could be no change to Article 5 prior to 1808. And that was a provision that affected the first and fourth clauses of the Article 1 of our United States Constitution. The founders, in particular, did not wish to allow for an amendment to make it to remove the language about banning slavery, or at least banning the importation of slaves within the United States. Many critics of our system unfairly claim that our system was somehow pro-slavery. But in other conversations that I'm sure you guys have had, you'll see the language limits the ability of the slave-holding states to use the slaves who were non-voting to have sway, overwhelming sway over our federal Congress. This provision reinforces that those changes won't occur. And in fact, our founders provided a provision that allowed for the banning of the importation of slavery, and Congress did so as quickly as it was allowed to do so. Now, the final provision is that no state, without its consent, can be deprived of its representation in the United States Senate. As a result, one of the things in the Articles of Confederation was there was no Senate. And as a consequence, there was no limit on the ability of any state to exercise a veto. We set up the Great Missouri Compromise, giving large states and small states an equal representation in the United States Senate, and then allowing popular vote to decide the makeup of the Congress of the United States. Article 5 says that that portion that affects the United States Senate cannot be modified. So that's my opening description of our Article 5. I want everyone to understand its purpose, its reason is to allow for changes, not hasty, not rapid, but changes to our system so that it is not what would happen with King John that led to the Magna Carta, but it also isn't what happened under the Articles of Confederation. We don't want a government that's too weak. We don't want a government that's impossibly too strong. And we don't believe, this is the founders talking, we don't believe that we know the answer for every problem that has ever existed throughout the recorded existence of our government. We want a system where people can, in fact, make changes, and we've set up a mechanism, and if one doesn't work, then we have another mechanism. If the congressional route doesn't work, then the state legislature route works. So with that being said, I welcome a conversation on this topic.
Well, thank you, Horace. That was really a great way to lead off the discussion. I love the historical context and love how you showed the progression of, or the, the how Article 5, its necessity in the founders' minds as they look back through history. And I'm going to turn it over to Jewel in just a minute, but I did want to ask, to me, the founders were just so prescient in their, and it's almost like they had the special ability to really see the future and to give us two ways to amend the Constitution. And do you think that they really believe that there might be some issues that the Congress would fail to act on, and that's why they gave us the second way to amend the Constitution, through the states, or through states calling for conventions if necessary? Or what do you think really precipitated them giving us two ways to propose amendments?
Well, a couple things. One is at the Constitutional Convention itself, there was a huge discussion that was led by George Mason of Virginia about the fact that our new Constitution did not have a Bill of Rights. George Mason drafted the Virginia Charter of Rights, and he believed no government could operate justly without this idea that there were specific limits. We have largely incorporated those particular amendments as what we call the Bill of Rights, the first 10 amendments. It became a stumbling block in the convention over those who said, we just don't think we could give government this kind of power. Now, our founders, and again, I'm bleeding a little bit into some of the other conversations that you guys have had in this process, but our founders wanted to protect liberty and the integrity of the sovereignty of the country by giving the central government the power it needed, but limiting its responsibilities. And they thought that that would mean it would be easy for you and I and the rest of the public to be able to thrive free from government. And so there were people like Alexander Hamilton that would have argued at the convention in Philadelphia, we don't need a First Amendment. We don't need a rule saying Congress may not restrict your religious activities or your freedom of speech or limit press, because our government doesn't have the power. It doesn't have a specific right to regulate in these fields. The anti-federalists, those who were worried about the fact that there was no Bill of Rights, they ultimately prevailed in a way. They were able to convince the founders that we needed Article 5 so that in the event that we discover that there are risks that the central government might pose with regard to our fundamental rights, our fundamental liberties, our fundamental beliefs and abilities, that we could subsequently change those. And in fact, an unwritten agreement was made that if we ended up ratifying the Constitution as drafted, it would immediately follow with it the submission of constitutional amendments that constituted the Bill of Rights. And it was this argument put forward by men like George Mason and by people who made up the Anti-Federalists that led them to say, we're going to have the ability to amend it, but we're not leaving this power just to the very central government that we're worried about abusing us. We're going to have a system that makes it possible for us to operate. And I just want to remind people one other fact. You see references to the states all the time. A lot of us today don't realize that in the time of the founders, the states were viewed as the embodiment of the protection for the individual, for the citizen. And in their mind, giving power to the state was the same thing as giving power to you and me. it is a remarkable change in the minds of people today that they often don't immediately think your state government and you stand in the same shoes when it comes to liberty. The founders wanted to make sure that you had the ability if the central government didn't ultimately reform. I hope I didn't run too long with that.
No, I love that. Thank you. We're going to go to Jewel now. I know Jewel's got some great questions lined up.
All right, what a great opening there. I always think it's so interesting when we talk about that debate of, well, they didn't need the Bill of Rights because the government didn't have the power in order to do those things anyway. So could you tell me, obviously, the way that history's proceeded, the government has done and infringed on a lot of those rights. So do you think that our Bill of Rights was almost not thorough enough? Or do you think that because of having the Bill of Rights, eventually it was assumed that, well, anything that doesn't infringe on those, the government can do?
Well, when the Bill of Rights was drafted, it was assumed that we were doing so as a dramatic and direct check limit on what the federal government could do. And those Federalists that supported the adoption of the Constitution continued to make the argument that government just does not have this power. You shouldn't be worried, but that's okay. We'll adopt these amendments anyway. Well, Article 1, Section 8 says that Congress has the power to make all laws which shall be necessary and proper. And under the Supreme Court's interpretation, it became obvious that necessary and proper became a broader and broader idea of what government is able to do at the central level or the federal level. And our Bill of Rights have really helped to provide limits to even, quote, what's necessary and proper. Our founders probably didn't guess that we would have programs like Social Security, programs like food stamps, programs like aid to families with dependent children, programs like federal assistance for education. And as a consequence, the prescience of someone like a George Mason is that government is limited when it's carrying out, quote, its necessary and proper responsibilities. It's limited in its ability with regard to the items covered by those Bill of Rights. The Bill of Rights has ended up being a clear champion, and after the 14th Amendment was added to the Constitution, the Supreme Court started using portions of the Bill of Rights against even state and local governments, saying that this amendment means that even your local state of Pennsylvania must operate under the same constraints that the federal government does.
It'd be so interesting to be able to just give one moment, one of the founding fathers, to just look at the government today and see what their reaction would be. Trying to limit my questions to the amendments. First of all, is there any limit on possible amendments? Is there, or if it did come to it, can anything be done in an amendment?
So, generally speaking, the amendment process is all but unlimited. As I mentioned before, there were some provisions initially placed with a timeline. The whole purpose of the amendment process description is to make it clear that a huge number of an interest, it's not just popular, not just the popular vote, a huge number of interests that make up America would sign off on it. When you have to get 3/4 of the vote, it makes it far less likely that something is going to happen sort of recklessly. 2/3 of the House, 2/3 of the Senate, and then you have to get 3/4 of the states to go along with it. That represents an inordinately high hurdle, but on the other hand, it has been done 27 times, and is evidence that there are needs and interests that rise to the level of important enough to occur.
And then as far as amendments that have been passed, besides the, let's say, I think the 16th Amendment is the federal income tax, I think. Besides the income tax, let's say, and besides prohibition, what amendment would you be most critical of, either the amendment itself or the wording of it, possibly?
Okay. Now that's a good question. I like it. I'm going to go with probably number 27, our most recent amendment. That amendment says that you can't vary the compensation for senators and representatives until an election has occurred. We managed to go more than 200 years without the need for this particular amendment. And the only thing that it appears to do is allow members to wait until after elections have occurred, the month after the election, to then vote for the increase in the salary, even though they realize that it won't affect them until after the next election occurs. I think that if you're concerned about your representatives being compensated too highly, you should probably take that out at the ballot box rather than as a constitutional amendment.
All right. Well, I think my time's just about up, so I could keep asking questions, of course, but let's get to some other panelists. Thank you very much.
Well, thank you, Jewel. Those are great questions. And we want to kick it over to Lindsay now.
Sure. Thank you so much for being with us. I just want to start by thank you for providing some of the history behind the necessity of Article 5. I know, at least in my experience, understanding the historical context behind these texts always aids in grasping the material. So I really appreciate you taking the time to touch on this. In your opening, you mentioned the creation of the Magna Carta in 1215 as an inspiration for limited government in America. And I was wondering if there were any other specific events or experiences under the British rule that influenced the founders to include Article 5 within the Constitution.
Yes. So in our Declaration of Independence, our founders specifically outlined the kinds of concerns that they had about the British system, which is a problem because the existing system at the time did not give you the flexibility to make any change. One of them is that the king, and I know that many people think that the veto power is a power that is created by the U.S. Constitution. But actually, in the British system, the king had to formally put his signature, some way of assenting to a law, and if he didn't, it was considered vetoed or rejected. There were no ways around this. If the king decided to make this change, he could allow a law to go forward, and if he didn't, he had the ability to prevent it. Our system wanted to make sure that the kinds of rules that a national government might make could be addressed. King George at the time regularly locked people up. He would have you arrested, and then he just wouldn't set a trial date. There was no grand jury. There was no appeal. There was no place that you could go. Our founders wanted to make sure our system, again, we take for granted that we have a Bill of Rights. We take for granted that the Eighth Amendment protects us from cruel and unusual punishment. We take for granted that we can't be forced to say or speak or make admissions against our own interests that could make us criminally liable. These amendments did not exist. And so our founders, with the Declaration of Independence, walked through so many of the types of complaints of a national government, and they wanted the ability that in the event that they saw things that were going forward, our Constitution would be able to do. It is, I like to tell people that it's amazing and wonderful, because it is, what our Bill of Rights represents. But in actuality, it is here are the things that government has done, and they have abused us, and they have wronged us. We're going to make sure at the beginning that these are included. And so that's why these amendments, after the Constitution was ratified, these were among the first amendments ever submitted. Our existence, our Declaration of Independence, contemplates that if you have a government, it can't be a government that does the kinds of things that King George did. And at the convention, they had to acknowledge there have to be ways to amend our Constitution so that the kinds of problems where government overreach occur, we can address.
Thank you. That's a great answer. And seeing that there were originally very few ways to incorporate change into government during the time of King George, do other nations of the 21st century have something like Article 5 written into their constitutions? And if not, how does their legal framework adapt to the will of the people?
All right, so most of the countries have used our entire system as a model for their constitutions. However, they are not identical, and they don't always operate with the same ability to be amended. But ours is the model. Ours is an example that has existed longer than any other written model. There are about 190 some countries that have constitutions that can be amended. The value of our system is what Benjamin Franklin said: I'm giving you a republic, a country with a charter that is governed by the rule of law. We pride ourselves on being a government with a rule of law, not men. It is not simply what's popular. It's not simply what everyone might like to have happen. Our Constitution and this particular provision help to protect the weakest minority that has ever existed. That weak minority is called the individual. Our constitutional system is intended not to simply make it possible for Washington to do the things that it wants to do to protect the integrity of the United States of America, but also so that you or me or any other single individual can operate free from restriction. I don't have to have the same religion as you. I don't have to have the same beliefs about guns as you. My individual rights are the thing that matter. And so the problem is, in writing, many, many other countries adopt provisions that are similar to ours. But at the end of the day, Russia is a good example of it. At the end of the day, they have amazing words, amazing language. It's beautiful to hear, but in practice, The individual isn't protected. The group isn't protected. In fact, they're not rights in any particular kind. A commitment to the idea that the rule of law, that's the test that operates. And we, as a country, model that. We embody that. And to the degree that we live up to that, it makes it more possible for other countries to do so as well.
That's such a wonderful point, because I think so often we take for granted the forethought of our founding fathers. And I was curious, from your perspective, with the knowledge of what some of the other countries look like today, what do you believe our nation would look like if not for the inclusion of Article 5? Would we even be a nation at this point?
So I think that without the ability of Article 5, we wouldn't actually have gotten the Constitution ratified to start with. The founders showed up at the convention and they agreed in principle. They did not agree to put it into the draft. They agreed in principle. We're going to have a Bill of Rights. The only way you can have a Bill of Rights is to have Article 5. The first 10 of the amendments that were adopted, we call the Bill of Rights, and they protect individuals and they protect the rights of citizens in these United States. Without them, we'd probably have had to go back to the Constitutional Convention again and start again, and this time probably not with a robust national government. Now, let me just remind everyone, while our founders never contemplated a government as big as the one we have, our founders were fearful of a government as weak as the Articles of Confederation. The French were our allies, but if we had stayed as weak as we were, they could have invaded. The British were not yet fully our allies. They did re-invade, and if we had not had a national government, they may have succeeded. Even Native American or Indian uprisings could have toppled our government. The war with Mexico, it couldn't have resulted in a far different outcome. The Article 5 made it possible for the government that we presently have to exist, and it makes it possible, if there are excesses today, for us to modify them so that those can be fixed for the needs and interests of our citizens today.
Very true. Thank you so much for taking the time to speak with us today. I think my time is up, but again, thank you. I really appreciate you taking the time to answer my questions.
Welcome.
Well, thank you, Lindsay. Great questions. And Horace, we've got so many audience questions. We're going to try to get we're going to try to get through a few of them. But all your talk about Bill of Rights, it reminded me of this great essay that you wrote for Constituting America in one of our 90-day studies a few years ago. I think it was called The Bill of Rights, America's Bulwark of Liberty. And you ended up dividing it into 25 things the government can't make you do, that ended up being the basis for one of the best-selling items in our Constituting America store, which is a poster. We made a poster out of your essay, and Jake just asked for it in the Q&A queue, so I'll drop that in here in a few minutes. But one question from Dave Mountney asks, is there a time limit on a proposed amendment using either the process of initiating one, in defeating, or ratification? And I know that question is timely, especially with the consideration of the ERA, because isn't that the big, that is a big issue right now on whether or not the ERA would go forward, is this whole issue of a time limit.
Okay, so formally, the Article 5 does not place a time limit on constitutional amendments. However, in practice, there have been a expectation that when Congress initiates an article, that it is going to put a time in so as to allow for a robust debate to take place. And when that time closes, that would be the basis of determining, yes, it's been ratified, or no, it has not been ratified. Prior to the 20th century, no proposed constitutional amendment had a time limit attached to it.
Okay. Then Martha Jenkins had a question regarding the issue, exactly how an Article 5 convention would work. Martha asked, Article 5 isn't specific about how an amendment convention would be set up. Is it true that Congress would determine who the delegates would be and the rules of such a convention?
Okay, so now we've got two types of references to a state convention. On the one hand, what we have is a Congress. Let's pretend we're going to use my little hobby horse. Congress wants a balanced budget amendment to be adopted. 2/3 of both chambers, the House and the Senate, adopt those, and they say that you have 8 years to consider this measure, and if you don't by then, this measure will expire. That has been the general practice for 7-8 years. They can either send it directly to the states and let the state government set up a vote by the state legislature, or they can operate what's called an Article 5 convention. That's different than the process for getting initiating a balanced budget amendment or any other amendment where Congress isn't involved. In the case of the former, like I described, then all that happens is that the state would decide what the qualifications would be for people to meet together at a convention solely on the question of what the state's position on a balanced budget is going to be. So two ways. One, we just simply let the state legislature vote, or we let the state, we say we're not asking the state legislature to do it. We're asking the state legislature to instead set up a ratifying convention. That's not that complicated. That doesn't open any doors up in any way. What opens the door up is when the Congress isn't involved at all. And that's when the states themselves initiate the decision. And in that case, Congress doesn't get to play a role at all in how the state carries out it. The state must formally vote to hold a convention. It doesn't get to say, I'm only doing this for a balanced budget amendment. It must formally request the actual convention, and 2/3 of those states must agree to do that. And then after that, all of those states meet, all of those states draft language, and then all of those states, that composite information can be then sent to the several states for actual ratification in both ways.
Okay, so the states would decide who their delegates are going to be to the convention if the state called for a convention. Okay. Robert Spiegler just has a comment. He says, just a comment here. I've recently seen 1776 and First American on Prime Video and really enjoyed them and recommend them for our viewing. So thank you, Robert, for that. And we also want to give a shout out to Terry Zalesnak and Hope Mucklow, who have homeschool students on with us today. And we're so glad that you all are learning with us today with our constitutional chat. So I think we can get to one more question here. Bill Herrenberg asks, has a convention of states to draft amendments ever been called? Has any effort to call such a convention ever come close? And what topic brought the states to action?
Okay, so I can answer that. There are a number of attempts that have taken place. The Balanced Budget Amendment, which I just happen to use as an example, is the model that has come closest to occurring. Some 28 states have already agreed, but it would require 34 states to agree to hold said convention. It is never occurred. It is as close today as it has ever been because there isn't any limit being set by the states at present on whether or not they wish to. There is a question as to whether if a state were to agree to call upon for a convention, if it could uncall or remove, nullify its request. So at present, we're as close as we've ever been, and the topic that has led to that is the Balanced Budget Amendment conversation. Here is my best guess. My best guess is this, that if you get close enough to calling a constitutional convention, Congress itself would take the language that people have been most interested in, and they would rush through to adopt it and bypass the need for the state convention process to occur. And I think any time any topic gets ignored long enough that it starts to lead to the states calling separately for a convention, you'll see this kind of pressure bubble up. But you need that. You absolutely need that as an outlet to encourage or force or insist on some of the changes that are what the American people want.
Well, and that's a great way, I think, to end this episode, and a great prediction. And we will be watching and see if that happens. So, Horace, we thank you so much for your time. This has been just a fascinating episode. And I know we've all loved learning more about how we amend the US Constitution. So I want to just see if, Lindsay, would you like to give any parting words for us?
Absolutely. So good to be with you all again. And I hope you have a great rest of your day.
Thank you. And Jewel?
Thanks, Horace, and thanks, audience. Great show.
Yeah, Horace,
Thank you, guys.
Thank you again. And thank you to our audience. And next week, we're going to be talking about Articles 6 and 7. So we invite you back. And remember, if you watch every episode in our Countdown to Constitution Day series, we will send you a downloadable PDF certificate of constitutional knowledge. And you can even go back, if you miss any, you can watch them in our archives at constitutingamerica.org and just let us know and we'll get you your certificate. So thank you for being with us. And Horace, thank you. We really loved having you.
Great organization. Happy to be here.
Thank you. Bye, everybody.